Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about blowing people up with pipe bombs. Cases that should have gone to the Supreme Court of Canada, but didn't. Okay, so that's a little bit dramatic. Brian Malley was convicted of killing a woman whose investments that he managed with a pipe bomb. The Crown's theory of the case, which was accepted by the jury at trial, was that he had depleted all of her investment funds and had killed her to cover up the fact that he basically lost all of her money. Mr. Malley argued at trial that there was another suspect who the police had not followed up on, and that essentially he did it, not me. Unfortunately, in Canadian law, you can't just say, he did it, not me, the police were investigating him, and then they turned their attention to me, and I'm innocent, without bringing an application to the court first. It's called a third-party suspect defense. And Mr. Malley was unsuccessful in that application. He appealed his decision. His appeal was unsuccessful, and he sought leave to the Supreme Court of Canada, which was denied. This case is very important because it puts a significant burden on individuals to persuade the court that the third-party suspect defense is viable. It's almost too significant a burden in the case of somebody facing a conviction for a very serious charge, a first-degree murder charge, the most serious charge known to our legal system. And Mr. Malley wasn't able, because of the procedures, as a result of this application process, to establish what was necessary to point the finger at a third party or even have the opportunity to do so in his trial. It's very difficult to lay an evidentiary foundation for a defense that you intend to run without the evidence to run that defense to persuade the court that you should be able to run it. The Supreme Court of Canada had an opportunity here to fix what is clearly a broken system that makes it far too difficult for people to persuade the court that somebody else is responsible for a murder they committed, and could have opened the door for a more fair process of raising these third-party defense arguments at trial. Unfortunately, the Supreme Court of Canada denied the opportunity to do so to Mr. Malley, and we'll have to wait until another day, which means another murder, in order for somebody to bring this opportunity forward again. That's unfortunate, and we could have had a more fair legal system had the Supreme Court of Canada taken this chance. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has put together these videos, so please like, subscribe, share with your friends, and tune in next week.